And toward the end of the deposition, when I was trying to get him to answer a question, he visibly got very upset. His counsel called a break. The witness, as he's walking out to the door, went berserk. Now, he showed up at the deposition with a mobility device. It's like a scooter that you rest your knee on and then you push with your other leg. It's a fairly significant piece of equipment. As the witness is cussing at me, he picks up the mobility device and he throws it and it hits the video camera and breaks the video.
Okay. Wow. Okay.
And then after that, after he throws the mobility device into the camera, he then starts rushing toward me with the appearance as though he's trying to unzip his pants, at which point his attorney, Tanner Foreman, puts his arms around him and wishes him out the room. On that same day, later that day, I sent an email to Tanner Foreman asking for new dates to complete this deposition. Subsequently, I noticed the deposition, and Mr. Foreman quashes it.
Or Mr. Foreman, is this all true? Did everything he's saying true?
Your Honor, we had put in the motion that we weren't available that date. My client wasn't available that date. We understand it. What it sounds to me like is that Mr. Ledyard is asking the court to compel the deposition. That's not what we thought we were here on today. And
I'm not following you, but okay.
Well, I guess what I'm saying is I feel like procedurally the proper motion would have been a motion to compel the deposition here today rather than asking for our motion to quash be heard when the date for that deposition passed a month ago.
All right, this is what's going to happen. Go ahead and share screening just so I can see.
Are you looking at my email screen?
Yeah.
Okay. And I'll also note, Your Honor, that at the hearing we had back on May 21st, out in the hallway, Attorney Tanner Foreman, I asked him again, and he said he was never going to provide dates for plaintiff's deposition. And that's just to go ahead and notice it, and I'll quash it. I have tried 3 times. I spoke to Miss Garcia in the Houston office of Jim Adler, spoke to her, explained to her the situation, that it was their client that threw their mobility device into the camera, and they need to replace his camera. This is this man's livelihood.
Mr. Foreman, this is kind of an interesting story. What happened?
Well, Your Honor, so just as a little bit of a background, my client is a disabled veteran he suffered a brain injury in this crash. He has anger issues. He's got a number of other problems. During the deposition, Mr. Ledyard repeatedly tried to trigger him however he could. My client was trying to give an answer. Mr. Ledyard would not allow him to complete that answer, and Mr. Ledyard told him that he needed to shut his mouth. At that point, I asked for a break, and my client was peacefully walking with his mobility scooter out the door, and Mr. Ledyard started questioning his veracity by saying that he didn't have a brain injury, at which point that again triggered my client to where he picked up his scooter and he threw it. And then at that point I got him under control. Mr. Ledyard said, "Hey, turn the camera back on. Let's keep rolling. Let him see him." Again, my client got upset. I controlled the situation. I got him out of that room. But our position is really, Your Honor, I mean, my client is the one that damaged the camera. He was triggered by Mr. Ledyard. I don't see how personally our office would be responsible for replacing any video equipment because of that. That's our position. And then it was what happened.
Let me hear from the videographer kind of what does he have on film.
The witness was combative and non-responsive all day long. After lunch, the taking attorney decided a new approach and was trying to get the witness to answer. This made him more combative. They took a break, and as the witness was scooting by using his knee scooter, he yelled profanity towards the taking attorney. As the witness got to the door, he yelled more profanity and became irate and flung his scooter and drink into the videographer, table, and equipment. The witness was restrained by his attorney from going after the taking attorney and removed from the room. After a break to see if things cooled down, the witness's attorney returned and said the depo is over.
All right, this is a strange situation, to say the least. I don't think I've ever seen this in 18 years on the bench. So let's kind of think through how we're going to move forward on this case.